to look for a third country for him, which would have been El Salvador. He could go to El Salvador because his parents fled and they were under attack because of the pupusa business. By Kilmar's own admission, the indictment alleges that the charged human smuggling operation began in or around 2016 and continued for a decade. Wild.
Rescuing children, it should be a nonpartisan issue. Everybody should be in lockstep on that, but they're not. The media's lying. The Democrats, they don't want President Trump to be successful. I got news for them. We are being successful.
That's right. A courtroom bombshell in the Kilmar case. Turns out his defense attorneys don't actually have key evidence that the judge was asking about, and they had to admit that in court. The article came out from Tom Papper. This is the case of Kilmar wife beater Abrego Garcia, who of course was deported to El Salvador. A lot of them flipped out and said, you can't send him to El Salvador. He had a withholding of removal order that said he can't go to El Salvador, but nobody has ever shown us that document. The only thing they've shown us is a court order, a written order that in the concluding paragraph talks about not sending him to Guatemala. And then the order is based on that conclusion. And so he was actually prohibited from going to Guatemala. So the question is, where is the original file that shows the judge said somewhere, remember they said, well, he addended it. He made an addendum and he changed Guatemala to El Salvador. All these people saying, what? Well, where's the addendum on that? Why didn't he update the official order? And how hard is it for Kilmar to have his defense attorneys or them to post out clearly it says El Salvador? Because it doesn't exist has always been our thesis on it, and the DOJ essentially missed it, and they don't have the file. This came out from Tom Pappert. Abrego Garcia's attorneys admit that they lack the file that would be used to claim that their client was wrongfully deported to El Salvador. And so here's the report. Attorneys with Murray Osario, the immigration law firm that's representing Abrego Garcia in his Maryland lawsuit, the civil case, remember they sued, said, bring him back here, against Trump, admitted in a Friday hearing before Judge Paula Zenas, you remember her, they admitted they don't have access to the A file that's associated with Abrego's case. Well, that sounds important. The A file contains the filing made on behalf of Abrego using the official government form for seeking asylum, the form I-589, the withholding of removal document, and relief under the United Nations, right? So here's the document and the filing instructions on how this works. We're going to begin collecting fees, they say, and there's an instructions tool. Here are the forms. Here is what one of them looks like, which we've looked at before previously, okay? And so they may come in here on this form and they may say, I can't go back to El Salvador, right? They can fill all this out. This is like, hey, judge, look at my case. Fill this out, information about you. Don't send me to El Salvador. Don't send me to anywhere, you know, pupusas are under attack down there, my mama and all the things. Total nonsense, but he fills it out. Now, he might have written in there, I don't want to go to El Salvador. It's not a preference. The judge, well, pick a country and I'll just prevent you from, no. There's got to be a lawful basis as to why we can't send you there. And we could send you to El Salvador is the thesis. So the judge said to save him that we're just going to change it. Even if you're requesting El Salvador, the only place I can legally say that you cannot go is Guatemala because his family moved to Guatemala and the mom was the one who was under attack because of the pupusa business. It's all logically lined out in the court filing. So even if, right, they filled it out on there that we don't want to go to El Salvador, it's up to the judge to make that decision. You ask for a lot of things when you go into a court and the court says, well, some of this is yes, most of this is no, but yeah, here's the one thing you went on. And at the time, he wasn't designated under the AEA or identified as MS-13, I would say according to Trump's new standards. And so he wasn't marked as high priority, and any withholding of removal at the time was just essentially allowing the person to stay because it was too much trouble to deport them. Now, the revelation was made by Abrego's defense attorneys in response to a question from Zenas. That's according to two people, Roger Parloff and Anna Bauer. They were both listening or attending the hearing, and here is what the judge said via Roger Parloff. Can you speak to, you do have the A file, right? Says Judge Zenas. Kilmar's lawyer says, actually, Judge, we have something called an EARM file. Now, we don't want you to assume mistakenly that it's an A file, and we have not received anything at all since he was returned to the US in June. Doesn't actually have that file. Well, I'm interested, the judge says, in what was done in 2019 to look for a third country for him, which would have been El Salvador. He could go to El Salvador because his parents fled and they were under attack because of the pupusa business, by Kilmar's own admission. So the Kilmar's lawyer says, well, we don't think anything was done. We have a form 790C. Government says, can we get a copy of these docs? Or somebody says, case says that. Now, I asked the witness, the judge says, about this. He had no knowledge of work authorization. And now Roger says, I don't know if it's Cooper or Rossman, a couple people there. All right, well, I wanted to pause to give the opposing time to ask questions. Okay, the original motion, says says the judge, ask for certain relief that you may be modifying or drilling down on. And you ask for two things. Don't remove him from the U.S. And she's talking about due process and whether there's a foreign country that he can be removed to. And so it will be well worth getting the transcripts. But the big takeaway is on this, they don't have the file, okay? So they don't have the final, let's say, check boxes that the judge wrote off on a checkbox kind of form document, right? To see, does it say Guatemala or El Salvador? Because the original order explains in the filing Guatemala. All right, so they say that Anna Bauer also said the same thing. Here is another post from them over on Blue Sky. Judge Zenas says, you have the alien file, right? Or the A file, which is the ICE file showing his immigration history. Like, you've got that. You're saying he was wrongfully deported, so like you have the records. Well, we have something called an file. Now, I'm not an immigration lawyer, and I don't want to say it's the same thing, says this lawyer, but we haven't received any updated file since he was returned. And says, well, we talk about work authorization and other things. So they don't have it because it doesn't exist, right? He doesn't have an order to El Salvador preventing him to going to El Salvador. If it existed, we'd have seen it. Maintained by the U.S. Citizenship and Immigration Services, an A file is the comprehensive record of an illegal alien's interactions with immigration authorities. A member of his legal team reportedly replied, we have the EARM file. Now, according to Homeland, an EARM file appears to be related to an internal electronic database used by ICE to track its detainees as their immigration court cases are processed, with illegal immigrants remaining within the system until they're deported. Now, it seems there is no overlap between the EARM file that his attorneys have, which contains information about his movements within ICE, and their client's A file, which contains the answers to the arguments that they made in 2019. Now, despite not having access to this file, his lawyers have said he was wrongfully sent to El Salvador, and I have no idea why, and we still have no idea why. Pam Bondi and the DOJ, in our take on this, have just misread the order and have just totally missed the whole thing. Or they have the A file and it says it in there, but his attorneys don't have it. The judge hasn't seen it. Though his attorneys have not seen the document, the form filed by Garcia would have contained the request for withholding, which was granted by Judge Jones, revealing which nation or nations Abrego sought to avoid. Now, within the text of the order, they say, Jones explicitly barred them from sending him to Guatemala, as we've read many times, citing the relocation of his family members who moved to Guatemala. He wrote, at present, even though the family has now shut down the pupusa business, the Barrio 18 gang is still attacking their pupusas. They continue to harass and threaten Kilmar's sisters and parents in Guatemala, where they moved. And they've also targeted the brother-in-law who also lives with the family in Guatemala. The judge also specifically wrote that there were factors in Guatemala that made it unsafe. Abrego can't go there. Therefore, the withholding was granted to Guatemala. They said he can't apply for asylum because he was in our country illegally for too long and wasn't actually here claiming asylum because he was here trafficking humans. However, he has established past persecution based on a protected ground and the presumption of a well-founded fear. Now, where is that going to happen? Guatemala. Homeland has not shown that there are changed circumstances in Guatemala that would result in his life not being threatened. Okay, you can't send him there because his life will be threatened. Therefore, his application for withholding is granted, right? And so their argument could be, if on this form he said El Salvador, Guatemala, and the other things, they could say, well, the judge granted the entire request. If it's even in there, right? It might just be Guatemala. I think it probably is in there. And the judge in his argument says, you have to have a nexus between the harm and the person making the request. And there's no nexus in El Salvador to the harm because his family's not there. His family is the mechanism by which the harm will transfer to Kilmar. And they move. So Tennessee Star, dropping another one. Now, Michael Patrick Leahy, the editor-in-chief, analyzed the document in a new series, saying even Alan Dershowitz had said the order didn't prohibit him to go to El Salvador. Alan Dershowitz is on board. He said the court was wrong. The court didn't read the briefs. The court didn't understand the case. It is a confusing brief, by the way. Like, we read it and just presumed. We had to read it twice before we're like, oh, this guy was not given the right to be in the country. The court had already decided he just wasn't deportable to Guatemala. Former U.S. DOJ attorney Iraz Ruvani was fired earlier this year after he conceded, and he was the poison pill. Like, he never should have conceded that. You never concede something like that when there's an argument going the other way. And there was an argument going the other way in the judge's own order in the concluding paragraph. So Iraz knew better. He was either unethical and poison pilled, or he was a moron and didn't actually read the order that he was supposed to prepare for and appear in court to prepare for. And the lawyer told the judge he had no justification for his client's actions. Yes, you do. It's in the concluding paragraph. But he wanted to just hit the Trump administration with a scandal from the beginning. Now, the statement by Ruvani ultimately led to the Supreme Court demanding that Abrego be returned. They ultimately brought him back. And the Tennessee was also the first outlet to report. Remember, he got stopped stopped in Tennessee, that he was stopped by Highway Patrol. The agency told the Star that troopers were ordered to release Abrego because Biden's FBI let him go. The dude was trafficking humans across Tennessee. Tennessee Patrol stops him. They're like, he's clearly trafficking humans. You can hear them talk about it on the body cam. FBI says let him go because illegal aliens get premium America. They can do whatever they want here. You get consequences, you go to jail, but they can drive around on suspended, revoked licenses, working for convicted human traffickers. FBI lets them go when they've got kids stuffed in their floorboards on makeshift back seats that they attached to the back of another convicted criminal's vehicle. Abrego was returned to Tennessee and he got indicted. He's pleaded not guilty and now he's facing charges there. Remember, the lower level judge said Kilmar's a nice guy, okay? He worked for a union and he only had 2 orders of protection against him for beating his wife. It was only 2. So whatever, don't be a bigot. And said he can go free. He's not a flight risk because of reasons. And Trump has responded. The DOJ sent the following. All right, the United States is replying to Kilmar wife beaters' opposition to our motion. The government said, we want you to revoke his release conditions. For the reasons outlined in the U.S. opening brief, and by the way, Kilmar's not going to be released. He would just go, if he's left criminal custody, into homeland custody and be deported. So once the judge said, we'll release him, then Kilmar's attorneys came back and said, actually, don't release him because it's just going to go over to Kristi Noem. Pam Bondi is just going to say, oh, it's not mine. Just throw the keys over to Kristi Noem. She's going to catch it and then take the keys and deport his booty. Then they responded and said, actually, don't do that. Keep him here. And so a lot of this is kind of going to be moot anyways, but the DOJ is making their point. Keep him in custody. You should have never granted this. Nobody else gets these benefits, right? If you're another person who's accused of crimes like this and you're a flight risk and you've got orders of removal and all these things, you would never get the benefit of the doubt where the judge writes 50-page screeds about how mean Trump has been to you. Never. But of course, this has been politicized like most of the judiciary thus far. It says, as further emphasized, this court should revoke this lower level magistrate judge's release order. You denied our request for pretrial detention. Here's why. Defendant Kilmar should be detained because there is no combination of conditions that can reasonably assure the safety of the community or his appearance in future proceedings. In a finding to the contrary, this lower level judge, in his opinion, he committed numerous factual and legal errors, and nothing in their opposition can justify his flawed analysis. Man, getting told right now. Rather, Kilmar now asks this court to adopt a wholly unprecedented legal standard that has never been applied in the bail hearing context at all, which even the judge declined to apply. Additionally, Kilmar also tries and fails to justify the judge's problematic approach to the overwhelming evidence that we presented. And remember, during the detention hearing, the government brought in a bunch of people. The defense, Kilmar's team, submitted an affidavit from CASA, an NGO that fights for illegals, which compellingly demonstrated that the defendant should be detained. And so you, the real court, should revoke the lower level judge's release order. Now here's why. Kilmar claims that this case law is binding, but it's misleading. It's not even true. It's completely off the mark. In fact, the Sixth Circuit's interpretation of that related to a completely different statute, not anything you're even talking about. Read the case. They never extended fields to cases involving bail reform. You guys even read anything? Look it up. Here's another citation. And other circuits have also done the same thing. And you guys are dumb. Not a single court in this country, not even Judge Holmes in her release order, has adopted the elements of fields for its analysis or what the term involves means. Ridiculous. Meanwhile, courts across the country have routinely applied the persuasive analysis in another case. And to our knowledge, not a single court has ever declined to follow the Watkins case until this judge in this case. Till this judge decided, well, I'm going to just be the president now and disavow any prior precedent and just do whatever I want. Now, to accept Kilmar's interpretation of the law, that would lead to wildly inconsistent and absurd results, including different meanings of the term involved based on different jurisdictions. As this case rightly points out, Watkins, if Congress wanted courts to apply an elements-based approach to this law, they would have done that. They could have written it into the law. They didn't. And if the court were to accept Kilmar's invitation, it would hamstring the court's ability to detain violent criminals because the standard would be so high. It would mean the government couldn't even seek detention for a violent shooter merely because the elements don't necessarily involve a firearm, if being in possession of ammunition. Or even more relevant, it would mean that a defendant who deliberately victimizes a minor, for example, by intentionally defrauding a child, could argue that the crime did not involve a minor because the statutory offense does not require the victim to be a child. So it's actually not a minor crime because I could have done it to somebody else who's not a minor. This is irrational. It would make no sense. And we would have to release basically everybody. And so the court should reject this nonsensical and dangerous request to rewrite the rules from the lower level judge. And more fundamentally, Kilmar's opposition fails to justify the speculative findings about the government's evidence, which was very sound. Kilmar says the court in a bail proceeding need not credit evidence that is unreliable. But that is not the factual record before it, and that was put before the magistrate judge here. Rather, our proof was overwhelming. It was corroborated, and it was otherwise uncontradicted by anything that you guys presented. For example, the lower level judge found that the government failed to prove by a preponderance of the evidence, which is a very low standard, like 51%, more likely than not, just a preponderance. You win. Government didn't prove it. Despite testimony, documents, body cams, all sorts of video, everything there said, not there, that human smuggling crimes charged involve any minor victims. And right, the minors, we saw multiple testimony about, even there may have been somebody in the car that night who was like 15 or something. But as the government pointed out in its opening brief, there was a wealth of evidence demonstrating Kilmar's years-long smuggling operation involving minor victims. Testimony from multiple cooperating witnesses directly participated in the human smuggling operation, and they discussed minor victims being transported there. Van Hollen loves it. Shifty loves it. Specific testimony from cooperating witnesses about how the defendant acted sexually inappropriate towards female minor victims. Little Jeffrey Epstein happening over there. The defendant used his own children as cover during the trips, exploiting minors for that, and testimony from another person called NV told the government that Kilmar solicited nudies from a 15-year-old girl and solicited her to participate in the alien smuggling scheme. Testimony and physical evidence from a traffic stop also demonstrated that a 15-year-old was being smuggled during that trip. Now, based on this evidence, we should have at minimum been granted the right to a detention hearing, but the judge said, well, actually, he says he didn't do any of that. He disagrees with all of your evidence, and so I believe him, said the judge. Says, like the judge's opinions, Kilmar attempts to downplay the most powerful evidence against him. Multiple accomplice witnesses who will testify about participating in this scheme for years. But as the court is well aware, testimony from accomplice witnesses can be highly probative given their ability to tell the jury about their firsthand knowledge of the participation. And for this reason, the Sixth Circuit has repeatedly held that the uncorroborated testimony of an accomplice may support conviction under federal law. Months in advance of a trial, this judge had no reason at all to discredit the testimony from cooperating witnesses that Kilmar was abusing minors, particularly given the testimony on the point from numerous respects, and there was no evidence at all whatsoever presented to the contrary. The judge's opinion essentially faulted the government for failing to call cooperating witnesses to testify at a hearing, and the hearing was merely just to be granted the right to seek a detention hearing, right? So it's not that they didn't bring them to the detention hearing. They just said, we need to get to the showing that we deserve a detention hearing, and it's such a low standard, it's basically, by default if you have a case like this. Now, finally, in addition, says Pam Bondi's DOJ, in addition to being consistent with the evidence introduced at the hearing, it's also consistent with common sense that minor victims, including unaccompanied minors, were smuggled as part of his sprawling human operation. The indictment alleges that the charged human smuggling operation began in or around 2016 and continued for a decade. Wild. And that guy, I think he was making like 100 G's a year. So he might have made $1 million or so coming off of human smuggling over his little time frame here. During the time frame, the human smuggling operation smuggled thousands of undocumented aliens for profit. The judge's opinion implies that not a single minor victim was ever smuggled. Not for nearly a decade. Not a single victim, despite the hundreds of thousands of unaccompanied minors that had been encountered at the southwest border during that same time frame. And so it's a matter of probability. And we're talking about preponderance of the evidence. On its face, that proposition is facially incredible. And so simply put, the judge's factual findings were completely inconsistent with the weight of the evidence under the preponderance standard. And the judge's findings about the danger also suffered the same flaws. Kilmar is a menace to society. The government presented evidence at the detention hearing relating to his possession of guns during the smuggling conspiracy, his sexual advances towards minors, his solicitation of CP from a 15-year-old girl, his disturbing history of domestic violence and abuse of his wife and kids, obstruction-related conduct during the course of the conspiracy, false statements and lies to law enforcement, membership in an MS-13 gang, a violent and dangerous transnational criminal enterprise, and more. Based on the full and complete record, the court cannot be reasonably assured that he's going to refrain from committing additional crimes. Like, if this were anybody else, okay, your son or daughter, God forbid, they're falsely accused by some lunatic in college of bad things, and you see what a judge does if your person has all of this stuff going on. You think they let them out of custody? No, not at all. But he's an illegal, so he gets premium version of America. He gets an extra presumption of innocence because he's better than us, according to our leaders. Says, and otherwise appear for all court proceedings in this case, given the potential penalties and the likelihood of deportation. Now, in suggesting that the court can rule otherwise, they attempt to explain or downplay the impact of each of this bit of evidence. But the record here, when you view it in its totality, compellingly shows this guy should be detained. As the government intends to once again show during the hearing, the evidence shows he cannot be released safely. Signed by Trump's DOJ, Robert Maguire, Jacob Warren, Christopher Eason, and Jeremy Franker, over with Task Force Vulcan. Now, they're also filing a bunch of stuff under seal that we can't see in this case. You can see this also got submitted in Tennessee. Motion for leave to file documents under seal. So US DOJ saying we got a bunch of stuff we want to send to you, Judge, and we're not going to see it in public. So we'll see what comes out. Tom Homan, who has been on this for quite some time, says we are actually looking for the missing children. Remember, the Democrats didn't care too much about that. When 300,000 that they admit missing kids gone. Tom Homan says we're going to get to the bottom of it because this is America and we can't have it happen.
Unbelievable that the Democrats are not on board. When you look at this raid, there were 10 juveniles that were illegally brought across the border. You and I covered this under the Biden administration. I was down in Texas. We encountered 8, 10-year-old, 12-year-olds coming across with just a name and an address and a phone number on their necks. The cartel ruthlessly sending them across. And yet now we know that 10 of them, 8 of which were unaccompanied minors working illegally in a marijuana farm. And your agents go in and rescue them essentially. And yet there is violent resistance to that. Does that upset you?
It certainly upsets me. And like I said, the work men and women of ICE are doing is incredible. Look, we're looking for over 300,000 missing children. We've already found 10,000. Have you heard that anywhere? No, the media is simply not covering it. And look, this should be a nonpartisan issue. Arresting public safety threats and national security threats, everybody be all the same page on that. Rescuing children, it should be a nonpartisan issue. Everybody should be in lockstep on that. But they're not. The media is lying. The Democrats, they don't want President Trump to be successful. I got news for them. We are being successful.
That's right.
Every illegal alien public safety threat we arrest makes this country safer. Every national security threat we take off the street and deport makes us safer. And we're rescuing thousands of children. The lives saved every day by ICE, the lives saved every day by Border Patrol, are in the hundreds. So the only thing I can think of, Griff, if they hate President Trump more than they love their community, they hate President Trump more than
100%.
they want, safe communities. And there's just no other excuse why this has become a partisan issue to take public safety threats off the street.
Yeah, they'd rather see their team lose than the one player on the team that they hate score the winning goal or the winning touchdown, right? They'd rather lose, the whole team lose, because they're just miserable people. And so even when something good is happening, like we have a control of our border again, and we're not being flooded by foreigners, they hate it. They want to be flooded by foreigners because they don't like Americans or America. And if you water it down into meaninglessness, then they can rebuild it in their own image and likeness because they think that they're God. And we know they're not. So we're going to keep covering this. Kilmar's attorneys now admitting we don't even have the file. And we'll be looking into this one continuously. Thank you for subscribing and joining as we do.